Well, hello. It's a pleasure to have this week as a guest in our global law program, Professor Joachim Rückert from the University of Frankfurt. Professor Rückert is a leading scholar in the fields of legal history, legal theory, and in German civil law. And he has come to Direito GV to teach a course on the autonomy of law. And I would like to start by asking Professor Rückert, what makes a German scholar come to Brazil to talk about the autonomy of law?
At first, I thank for the nice invitation, and secondly, I know Thiago Reis rather well because he studied at Frankfurt on Main a longer time, and therefore I took a I found very charming the invitation. And why a German scholar on autonomy? I think I studied the autonomy problem especially for the 19th and 20th century, and it was the result that the German case is paradigmatic not only for Europe but even in a global perspective. For example, I made some studies about the Chinese evolution in the 20th century, and we can see that the Chinese way comes late and begins in some way analogous to the Prussian way in the 19th century, and there was always the problem of autonomy of law.
But if you look at the literature, autonomy is largely dealt with, autonomy of law as a topic is largely dealt with from a theoretical perspective. Why do you think this historical perspective is important?
As philosophy or theory without history, that means an empirical side, is not very useful. It remains to be theory, and therefore one should have a look to the real circumstances of this autonomy of law. And therefore I studied it, and the combination of theory and history as the combination of abstract ways and more empirical ways, I think is very useful.
What would you say, so one of the challenges of the course is to try to combine both these theoretical and historical perspectives. But what makes the German case, which is at the core of your course, so paradigmatic? What would you say the 19th century in Germany is so special that it serves as an example for the autonomy of law?
You know, we say the 19th century was beginning after the French Revolution in Germany with this revolution of spirit, and we had a very sharp discussion about law and balance of powers and theory of law in the whole 19th century, and the quality was very high, especially because Germany at that time was a leading nation in philosophy and theory and even in law, in jurisprudence. And therefore the German case has a certain interest not only for Germany.
And would you say that the literature and the knowledge produced in Germany during the 19th century has had a global impact?
Not the whole literature, naturally, but I think some authors are really instructing even in a global perspective today. For example, Savigny or Jhering, and even Marx, we spoke about Marx too, is evidently in a global perspective important. So
the course, let's talk a little bit about the school and your experience here at the law school as part of the global law program. How was the course? Normally has participants of different nationalities. I think this course particularly had participants from over 5 nationalities. How was it? How is that experience to teach this very hard subject to a very diverse audience?
I think the students were all very disciplined, were a little shocked in the first moment about the challenge of the course, and I was not shocked because I'm accustomed to the shocks of the students. And in fact I saw no difference in the background, no relevance of the different backgrounds. It was new for all of them, and the parallels for their own cases were a little in the heads and not outspoken very much.
But do you think that does it say something about the subject? about the autonomy of law, that it is a subject that can be communicated to different cultures, and practically every lawyer in every country can relate to that problem?
Yes, I think so, because it's, on the one hand, it's rather abstract. On the other hand, it's really fundamental for each legal order and legal system. And the question whether the jurists should work more narrow for themselves and literally following the laws is a question in any society which has juries. And the background of the students is so that they all have jurists in the background.
But I know that we as historians are very, we try a lot not to emphasize Eurocentric views, but would you say that these lessons that can be learned from the German experience in the 19th century can be useful to developing countries such as Brazil, India, China, or other countries here in Latin America, for instance, this problem of the autonomy of law and how we deal with it from a theoretical and from a historical perspective?
I think in Latin America it's rather easy to transport the insights. It would be more difficult for Africa or China or the Muslim countries, but I'm sure that the legal order you will find in any society, whether it's the Qadi or the state judge or other forms of working with the law, and therefore even the Qadi justice has the phenomenon of a certain autonomy, especially because he is not so bound to law. He has the autonomy in itself as figure, as role, as professional role. And therefore you can discuss autonomy problem for the Qadi too.
Professor Rückert, thank you for being here. Okay. It was a pleasure to have you.
I have to thank very much. Thank you, Thiago.